Hi, my name is Alex Dolphin. Welcome back to another episode of Ex Ante. Today we're going to discuss the case Batson versus Kentucky. This case was heard in the Supreme Court of the United States in 1986. Mr. Batson was a black man, and he was charged with robbery in the state of Kentucky. Now, during the jury selection process, otherwise known as the voir dire, the judge and the prosecutor and the defense attorney are basically going through the jury pool, and they're going to select the people that will be on the jury that will serve during the trial. During this process, each side can have two ways to remove a juror from the pool. The first is a for-cause removal. Essentially what the side is going to do is argue and say, hey, this person doesn't believe that burglary should be a crime. That's a bias. We need to strike them. The judge is probably going to say, yeah, we agree. This guy needs to get out of here. Or this person is related to a police officer. There's obviously going to be a bias in favor of the police because they're married to a police officer. So we got to get them out of here. So that's a for-cause removal. And each side is going to have unlimited for-cause removal of jurors from the jury pool, trying to eliminate that bias and make sure there's an impartial jury. The other type is called a peremptory challenge. Now, in a peremptory challenge, each side is going to get a certain amount. It might be 6, it might be 10, depending on the type of the case and the jurisdiction. But each side is going to get to say, I just don't like the way that juror looked at me, and I'm going to remove them. You can remove those jurors without any explanation. That's the point of the peremptory challenge. Now, so the prosecutor in Mr. Batson's case looked at all the jurors. There were some black jurors in the pool, and the prosecutor used the peremptory challenges to get rid of the black jurors. Right? There's no explanation needed in this system. So that made it so that the jury that ultimately convicted Mr. Batson had no black people on it at all. It was only white people. Mr. Batson objected to this peremptory challenges where all the black jurors were taken out of the pool, objected to the prosecutor's actions. The judge said, well, these are peremptory challenges. The prosecutor doesn't need to provide an explanation. The Equal Protection Clause doesn't really apply here. So sorry, but there's nothing we're going to do. Well, Mr. Batson appeals this case to the Kentucky Supreme Court, which rules against him, and then all the way to the United States Supreme Court. And the United States Supreme Court ultimately decides that the Equal Protection Clause protected Mr. Batson from this type of discriminatory behavior by the prosecutor in this case, where the prosecutor was using peremptory challenges to remove black jurors from the pool. Now, essentially, what happened here was this was a violation of equal protection, right? Because the defendant was black, and these black jurors might have been more sympathetic to him. And so that is why the prosecutor removed them. So in Batson, the court says that violates equal protection, and it gives us a test. That test is a little bit, it's evolved since Batson in the sense that now this applies to both the defense and the prosecutor. So a prosecutor could bring a Batson challenge as well. It's also evolved a little bit that it doesn't just apply to race. So the races don't have to be aligned. It doesn't have to be the, Hispanic man and black jurors are struck, or it doesn't need to be black and black, if that makes sense. That's kind of the way it was worded in Batson. Also, it applies to gender now too. So if a man was on trial and the defense struck all of the women from the jury pool, you could also bring a Batson challenge. So what's the test? How do you effectively bring a Batson challenge in saying that one side discriminatorily used its peremptory challenges to get rid of a certain type of person from the jury pool, whether that be on a certain type of race or gender? So first, the party challenging needs to show a prima facie case of discriminatory intent or discriminatory purpose. Prima facie is just a Latin term for saying on its face, so a facially discriminatory action. The court can consider wide latitude of facts and circumstances to ultimately make this opinion. Now, so if there's, 4, just for instance, maybe say there's 4 black jurors in the pool, the prosecutor strikes 1 but leaves the other 3, it's going to be harder to show a Batson challenge. But if, like this case, all 4 black jurors that are in the pool are struck, then it's going to be a little bit easier to make a Batson argument. Now, you don't have to look at the prosecutor's prior actions. I mean, you could, but those aren't essential. You can just look at the prosecutor's actions in the trial to see, is there a prima facie case? Is there discriminatory intent in whoever was striking that person, that type of race of person from the jury pool. And so that's going to be the first step. Now, if the person complaining is effective in showing that there's a prima facie case of discriminatory purpose or intent, then the burden is going to shift to the other side to provide a race-neutral explanation, essentially saying, well, we didn't strike that person because they were black. We struck that person because they're a male person, and we think that male people will be especially harsh on crime. And so you just need to provide some other reason. The court says this doesn't need to rise to a for-cause reason, so you don't have to show like this great amount of bias. All you have to do is just provide some reason that's not based on race. So that is the Batson test. Now, you can see right off the bat that it could be relatively toothless, and this is exactly what Justice Marshall says in his concurrence, is saying that, yeah, you know, sure, this is great. This is a step in the right direction, but ultimately prosecutors, defense attorneys, people that are striking, using their peremptory challenges to strike certain racial groups from the jury pool are going to be it's not going to be too tough to come up with a race-neutral reason. You can kind of just do that ad hoc. And it doesn't need to rise to the level of for cause, so it doesn't need to be super distinct. And so it's kind of the toothless test. And Justice Marshall says we really just need to get rid of peremptory challenges altogether. Anything that's for cause, sure, get the jurors out of the pool, but just you have a hunch, you have a feeling, there's just too much possibility for discrimination there. He says peremptory challenges just need to be gone if we're really going to believe that certain people will have equal protection under the law, that all races will. Now, Justice Rehnquist and Chief Justice Berger write an opinion that it reads, frankly, a bit racist today, but to just kind of steelman their argument, it is that these peremptory challenges, they go back to common law in England. These have been time-tested. They're a true part of the jury system, is that you should be able to just strike people without giving any reasons. And this promotes fairness in the justice system because, yeah, you might not be able to give a reason why you think that person is biased, but if you can get the feeling that they're biased and you can sense that somehow, then you need to be able to strike them to ensure fairness in the jury pool. That's essentially their argument. The other argument is that this just wasn't briefed in the court below, and if it wasn't briefed, then just, you know, as a matter of judicial restraint, we shouldn't go this far. We shouldn't create this whole new test and this whole new rule that basically is what they would say is gutting peremptory challenges unless it was actually briefed before us. And they actually cite some portions of the transcript saying that the petitioners didn't even really want this to happen. This is an act of judicial overreach is kind of their argument. Now, they also say it's kind of a slippery slope. If you allow this to happen for race, then it will probably happen for gender, which it did happen for gender. And then also they say like employment types, different things here. As far as right now, it's race and gender. The slippery slope argument hasn't come completely true, though it has expanded to gender. Now, just essentially, like I said, the argument there to steelman it is that if you're even going to do this to prevent, these racial peremptory challenges, racial-based peremptory challenges, as soon as you do that, you're kind of gutting the peremptory challenge system, and it's going to reduce in a lack of faith or fairness in the jury system. You can see that taken either way. That's their argument, though. So thanks so much for watching. Hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. Hope you have a nice rest of your day. Bye-bye.